Good afternoon. Today I'm going to say something about the important doctrine of promissory estoppel in contract law in the context of a very recent decision of the Supreme Court of Western Australia, in fact the Court of Appeal, Wilson, W-I-L-S-O-N, and Arwon, A-R-W-O-N Finance, 2020 WASCA at 132. And putting the matter very briefly, a borrower who had borrowed some money from a company alleged that it was part and parcel of the arrangement between the parties in terms of representations made which he'd relied upon, that any debt which he incurred in relation to borrowing money from the company would not be enforced until the proprietary interest he had in certain sandalwood and other products was satisfied. In other words, they would look first to the trees, as he said. They will first of all come after the things that are growing in the ground, and if they're insufficient for whatever reason, then they may turn around, and sue me for the money. He said that hasn't occurred, therefore I'm not liable for any debt. And it's a tricky area, this question of estoppel, because an estoppel in law French means just effectively that you're stopped from asserting something. You're stopped from asserting a particular legal right or a particular position you might otherwise assert under a contract, because the Court of Equity won't allow you to act unconscionably by diverting or ignoring a promise or representation which you've made, which the other party has relied upon to its detriment. That's the key thing. So we need a representation of some sort, we need reliance, we need someone relying on the statement that's been made, and then we need detriment. And it's often said, as we'll see, that the court will only protect the minimum detriment necessary to prevent unconscionability. And it's clear from the judgment of Chief Justice Quinlan and Justice Vaughan that unconscionability is at the base, if you like, or the root of any question of promissory estoppel. Part of the problem in this area, I think, is that as their honours point out in paragraph 81, there's no acceptance of a unifying, overarching doctrine of estoppel in Australian law. We've got successive High Court cases, we've got dicta, not all over the shop, but looking at the matter from various perspectives. And it's not easy to actually tease out all the dicta, all the rules. But the doctrine was explained by the joint judgment at paragraph 82 in this way. Their honours tell us that the doctrine of equitable promissory estoppel operates to prevent a party, who we will refer to as the charged party, unconscientiously departing from an assumption or expectation which it has induced another party, who we'll refer to as the claimant, to adopt, and to act in reliance on it to its detriment. So you've got the various elements I discussed there, and we're looking at the question of whether it's unjust or unconscionable to depart from the particular position which has been induced. Classical case you probably remember, the foundation of a doctrine really, 1946, the High Trees Doctrine, where the landlord had said to the tenant, well, wartime's finishing, times are tough, it's a bit like now really, no COVID legislation, but you don't need to pay me any rent for a couple of months, a few months, but when I give you notice you'll have to start again. And the question was whether or not the landlord could go back on that promise, which of course was a legal promise under the contract, on the basis that to do so would be unconscionable as a matter of equity. And Lord Denning, that wonderful equity judge, said, no. If you've made a statement which is relied on by the other party to its detriment, then you can resile from that promise upon giving notice. You can say, time's up, we're back to the old position. But until you do so, the other party is protected from the strict enforcement of the legal promise. And that still is pretty much the position. And we've got a few key cases from the High Court early on. We've got Walton Stores, Interstate and Mar, in which Chief Justice Brennan lays out 6 basic propositions which we need to satisfy. First of all, we need to show that the claimant, that's the person relying, has assumed that a particular legal relationship exists or expects a relationship will come into existence, and that the other party won't be free to withdraw from a legal relationship. Then, secondly, that the person involved in the representation has induced the plaintiff to adopt the assumption or expectation in relation to the business, lease in that case, if you remember. Thirdly, that in reliance on that particular statement, the plaintiff, let's say the person relying on representation, has acted on the assumption or expectation which has been induced. Fourthly, that the defendant knew or intended him to do so. So it can't be a question of mistake or some mutual error. There must be an actual intention to induce the other party to act on the basis of the statement. Fifthly, the plaintiff's action or inaction will occasion detriment if the assumption is not fulfilled. No problem with that one. And then finally, the defendant has failed to avoid that detriment, whether by fulfilling the assumption or expectation or otherwise. So in this case, the defendant in the bank case or the money case claimed that he'd acted or had been induced to act in terms of entering into the transaction on the basis of representation made, that they wouldn't attempt to collect any debt from him in terms of money until such time as they'd come against the trees, as he said, until they'd exercised security. One of the problems, factually, which we needn't go into in too much detail here, was that it didn't seem to the Court of Appeal on the facts as found by the primary judge, but that was a main motivating factor, this question of where they'd look for the money. And that was because, like many of these schemes involving agricultural products, the whole scheme was tax-driven. It's a usual type of operation where you pay a large amount of money up front and you get an immediate tax deduction for that particular tax year. And you get a ruling from the tax office in relation to it. And that's what had occurred here, which as a factual matter, even though there were slight errors in the first instance court's decisions, meant that there was a bit of a problem in relation to demonstrating the reliance. It follows, of course, that you need to have, as they say in the classical cases, a degree of clarity with respect to the precise representation. It's got to be pretty clear what the representation is, and it must be pretty clear how you're acting on it. Secondly, in terms of the detriment that you've got to demonstrate, that's not a narrow or technical concept, we're told. It's got to be substantial detriment. It can't just be some minor thing that's happening, but it need not involve the expenditure of money or to be quantifiable in monetary terms. So, the court doesn't necessarily have to be able to quantify the loss you're suffering, although frequently in the cases, equitable compensation might be awarded in relation to the monetary loss rather than strict enforcement of the promise. But, however, as the court says at 99, paragraph 99, there's no real detriment if the claimant asserting the estoppel would have been in the same position in any event. In other words, if whether or not the statement was made, you'd still be in the same position, then there won't be any estoppel arising. Finally, and importantly, the estoppel, which is acting in conscience, it's stopping the other party from being unconscionable about it, gives rise to an entitlement or obligation of which a court of equity will take cognizance in claiming the benefit. And the remedy required, as I've already said, to satisfy the equity varies according to the circumstances. So it may or may not call for the assumption or expectation to be fully fulfilled, or it may simply look at some lesser amount or some lesser action, as long as we're looking at what the minimum equity is. That's the key point. And so we've got to look here at what good conscience requires in all the circumstances that the party making the representation be required to do or prevented from doing. So, a very interesting case. It's well worth reading. It's a tricky area. It comes up all the time, of course, in contracts. People say something is said, and you need to look at it pretty closely. Have a look at the case, and I'll talk to you again soon, and I hope you're all keeping well.